right, so this panel, we're talking about industry changes. And I know that's kind of a broad title, but we're going to kind of speak specifically about some of the commission lawsuits, which got brought up in the panel before, and so I was glad that it did, because I think that'll give us some good talking points. But let me introduce my panel real quick. We've got Romeo Manzanilla from At Properties, COO. We have Emily Chenevere, the CEO of AWAR. And Chris Heller, who is the president of Ojo Labs. So lots of trustworthy names up here that I wanted to make sure that we had people that were speaking that you guys could recognize and understand and trust. So let's start off with kind of a broad question and to kind of work backwards. What do you guys think are the biggest misconceptions or, falsities that realtors know or think in regards to the commission lawsuits?
I'll start. I think the very first thing is that a lot of realtors don't think it's going to affect them. And that's really where it comes down to being educated and really knowing what the lawsuits are all about and what the basis is and the misconceptions that the consumers have about realtors and how they're paid and how the process works.
Emily?
Yeah, to put a finer point on it, I think the misconception is that agents believe that this conversation is about whether or not people should be represented on the buy side of a transaction. And that is not what the claims are about at all. They're about how the buy side gets paid and whether that being a constraint or condition of participating in the MLS is something that should be or not. So my encouragement to you really is this is not about your value as an agent or the value that you provide on either side of the transaction. It's about the transparency and conditions in which you are commissioned.
Yeah. And that could translate into a discussion about value, all right? Because you're going to have to be able to explain what you do and how you do it. As far as misconceptions go, I think, and I don't know that's a misconception. I just think that a lot of agents are sort of taking the wait and see and tell me what I need to do, tell me what I can to approach instead of proactively preparing. And I think that's, again, not a misconception. It's just a behavior that I see.
Why do we think they're doing that? Is it a lack of information being put out there or too much information maybe? The wrong information?
That's a good question. Yeah, I think it's probably a little above, a little of all the above. There's, either not fully understanding, not slowing down enough to take the time to understand, not knowing how to prepare or what to prepare for. So there's all those things. But ultimately, no one knows what the final outcome is going to be or look like, right? There's a wide range of possibilities. So there's everything from preparing for the worst case scenario or preparing for a likely scenario or those. So I think those are all things that contributed to people not doing anything or not taking any action.
And Emily, I might go to you for a second and just, since we kind of went back and talked about what we think we don't know, give us kind of the fast and dirty on where these things are at today, if you could.
Sure, yeah. So I checked with our attorneys, whom I speak with on a daily basis now, and there are 18 claims across 10 states today-ish. That can change at any given moment. But this all started with one claim, with a set of antitrust claims, class action level, filed in a case called Merle, and then quickly kind of snowballed following the judgment in the first copycat called Sitzer last October. But the thing that you need to know is that the claims are very similar. The arguments, the conversation that we're having in any one of these complaints that's been filed are all very similar, and I think that there will be at some point an outcome that gives us the assurance to know how to move forward. When I think about your question of why are people so confused, there's a balance we're striking between not creating fear and not telling you guys to stop doing what you're doing and to, act with such caution that you feel stuck in analysis paralysis in your business versus helping guide you, providing best practices that really have always existed in this business or should have, and encourage you to continue in your business confidently, but being aware and open to the fact that change is going to come. And so I think, we're and then doing that in a way that the Office of No, which is another name for attorneys, will allow for us to talk about it in any one of these states or brokerages or MLSs in which we've been named. So I think all of us are really trying to figure out what is that balance of educating, talking about this openly, preparing you for change, and not scaring you or stifling you in your business so that you feel constrained from doing what you do and serving your clients well.
And I'm going to pick on you one more time. So can you give us a little bit of, I think that there was probably a lot of eyebrows and just aha moments when this finally got a little closer to home. Can you give us a little bit of basic information on that case?
Yeah, so where ABOR and Unlock MLS are, because both entities, those are separate businesses, have been named in 2 different complaints here in Texas there was first a complaint that we referred to as QJ Team because of the name of the plaintiffs filed last November, filed against the Austin Board of Realtors, 3 other very large associations across Texas, Texas Realtors at the state level, and a number of different brokerages. The claims filed were filed under the Sherman Act, which is the federal antitrust law, filed in a district court in North Texas and assigned to a judge out of Plano. And very similar, as I said, in nature in terms of the arguments being made with regards to their likening back to Merle and to Sitzer. Then, just a bit after that, another claim was filed, this one based on the buyer side of a transaction. The QJ Team was a seller side set of claims. These buy-side claims were filed shortly thereafter by the same plaintiff's attorneys. We call that one Martin. That one named the same associations plus more associations plus MLSs independently and a new set of brokerages as well. Similar claims, very similar arguments to those made in the QJ Team, which are very similar to Sitzer and Merle, and very similar to the other 18 plus claims that exist across 10 states. Your initial opportunity or action in any one of these claims, not us specifically, but just what happens next is you make a decision about whether you're filing a motion to dismiss or a motion to respond to a claim. And so that was the initial action before us to consider. But right now what has happened is a little unique. Our 2 claims have been grouped into a motion to call for something called multi-district litigation. This is an MDL is an effort in the judicial system at a federal level to bring all of like complaints together into one suit so that from an efficiency standpoint, your discovery process is faster. The idea is that the judge can rule faster on any one of the claims, even where there are nuances in them, and you get grouped together into this thing. Whether or not you end up in what's called an MDL is decided on by a panel of judges. So there are judges that get to decide if the MDL exists, and then they get to decide what venue, what court will take on this grouping of cases. So where we are right now is a bit on pause as we await the outcome of whether or not the MDL is ruled on in one way or the other, and then if it is agreed upon, what venue will be in terms of those claims. If you want to hear more very specifically about the claims in Texas and the 2 that ABOR and Unlock MLS have been named in, I hope that you'll tune in to the annual member meeting on January 31st at 10 o'clock. We're sold out in person, but we'd be happy for you guys to stream. Our first seat trial attorney, Jay DeWald with Rose Norton and Fulbright will be there. And then more importantly, Mitch Skinner, and I don't say that because Jay's not important, he matters, but Mitch Skinner is, with Larson Skinner, is a preeminent attorney in our industry, has been closely watching this legislation and MLS policy at large across the nation for years, and is also on our team, and is gonna share more information about broadly the arguments, the specifics of all of these different cases, and just how kind of help enlighten everybody about what the heck is going on with these things? What does it really mean? So I really, really encourage you to tune into that meeting on the 31st.
Chris, I'm going to go to you for a second, and thank you, Emily, for all that good information. Do we think that there's opportunity, or maybe somebody's already taken advantage of what seems like an opportunity for me in the technology space, where our industry is changing? There's going to be new things that have to be, new challenges that have to be overcome in the real estate process. Do we see technology playing a part as they help us ensure compliance and navigate the changes?
Yeah, I think absolutely. I think there's going to be a lot of opportunity, period. And whenever there's change in a market, change in how things are done, it creates opportunities. So I think there'll be no shortage of opportunity. As far as technology and being able to provide, like Emily said, some of the things that are going to be, I think, absolutely necessary, like transparency and being able to how things get, being able to effectively communicate things. I'm sure that technology will play a role in that. There'll be products and tools and processes that leverage technology to do that. I think the opportunity of change will come in a lot of different ways, because we'll have people that it's like when the market changes, right? Some people are very quick to adapt and to look at, okay, where's the opportunities of this current market, and they'll take action and be proactive and ride that wave. Others will not take action or not pay attention or sit back and miss out on those opportunities. So it's being aware, doing what you're doing today, being at events where you can stay up on things and be educated and be able to be positioned to do the things that need to be done.
So I also want to say, technology is there to help facilitate, create efficiencies, but it's not the end-all, be-all. It comes down to education. And who's responsible for keeping agents educated? Well, first of all, the agent has to go out and pursue that information. And then it comes down to brokers as well, making sure that their processes, that their compliance, that their rules are not only in place, but being followed. Because if you don't have a rule and you get caught in a lawsuit, it doesn't necessarily have to be a commission lawsuit, just any lawsuit, the first thing an E&O company is going to look is your policies and procedures, and whether or not you have a rule or a process that addresses that particular situation. So definitely take it upon yourselves to attend the annual meeting, to research and find the information, because the better informed you are, the better informed your clients will be, and that's how you break through a lot of these misconceptions.
Do we think that there is legislation or that, Trek or somebody will eventually get involved from a governmental standpoint? We see other states that have more oversight in certain areas.
Yeah.
So,
watch my careful ease into this question.
I understand. Yeah.
No, there are states where buyers' representative agreements,
Right.
buyers' reps, are mandated, and that is not the case in Texas and could be in the future, which would add to the transparency in the conversation forced between buyer and the representative about your services and what they're worth and how much they cost based on whatever that conversation is for you. So I think that kind of thing comes to mind. Potential changes to the IIBS that help provide transparency to that conversation as well. And then, pending what kind of outcomes happen as a result of any one of these cases, there is the potential that there is licensure law needed to accommodate whatever change is forced, or that we need to think differently about what the rules are within Trek. When you think about these aspects of our business, the way that your license hangs with a broker, the traditional licensing components of the state, they're very legacy. This business has not changed that much in a long time in terms of those real anchors of how the business operates and what it means to be licensed. And so I do think that realistically and reasonably, pending what the outcome is, you're ripe for some change in some of that structure. And I hope and believe that Texas Realtors will work with the Texas Real Estate Commission to perpetuate that change in a way that's efficient and that works for the business and works for the industry.
So there's so many sources of information out there. What do you guys feel like is the best? If somebody walked up to you today and said, where can I go to get the best and most accurate information? Where do you send them?
Probably not Inman. No, but Inman is great about scandalizing things, right? And there's a lot of great information in there, but they're a publication company, and they're worried about subscribers, and they want eyeballs. NAR has been as transparent as they can be given the litigation, but you have to think any organization is going to have a bias, right? And in how they present the information, but definitely. NAR, Texas Realtors here, ABOR, trying to be as balanced with the information that is being presented and truthful and timely as well.
Well, the right answer was Abor, but good try. I'm just kidding. Look, we're trying really hard to communicate as effectively as we can and proactively as we can to the extent the attorneys will allow it. And so, at a minimum, trust that what we're telling you is accurate and true and as timely as possible. That does not mean that we are able to share every detail that we wish we could share so that you'd have a full understanding of what's going on. And I think what's true in our culture generally, this topic or any other right now, is that it takes a whole bunch of news sources, a whole bunch of different facts coming together to figure out where the truth lies. I think that's true still in this. There are tidbits of what happens in Inman that are pertinent, that you need to know. There are tidbits grabbed from Real Estate News, the new T360 real estate service, that I think are pertinent, that you need to hear. There are things that your broker will say that are different than the things that I can say at Abor or on Lock MLS. You need to work hard to hear all of the things that are going on, and then let's put that together and figure out where the truth lies in the middle of it all. But please know that anything that we're saying is accurate, is true, and as timely as possible.
Do you have any other ideas there, Chris?
No, I would just add, there's places not to get the news, right?
That's a good point.
And so we know where those are, right? I love social media, but that's not the place to get facts more times than not. So, what you heard up here are the best sources.
Okay, so if you're talking to agents here today and they say, gosh, this sounds like a lot, where do I start? What's one thing I can do today in my business to help what's the most important thing I could do for myself today?
I think you have to be very transparent with your clients, right? I mean, you're providing a service, and you should be paid for your service, right? And I feel like a lot of times on settlement statements, agents are sometimes almost kind of embarrassed about the amount showing on a settlement statement, and you shouldn't be. I mean, if you've provided a service that is at a very high level, served as an advisor, been transparent about the process, then by all means, you deserve to be paid on that transaction.
There are two things for me. You need a buyer's rep agreement in every deal you do, and you need to get it before you go to slip the contract into your broker's office. Like for real, at the front of the transaction, when you retain the client and begin your agency relationship, you need a buyer's rep agreement and a transparent conversation about what your value is, how much these services cost, and how you're going to get paid. That's the only thing that says that you're actually going to get paid. So for you, that is critical. For these lawsuits and your risk and your broker's risk, that is also critical. The second thing that you can do is to stop talking about commissions on social media. Just stop. There is never a good outcome from that. The conversations go down a rabbit hole very quickly, and then you're associated with them directly in a paper trail that is written at a time that there is immense risk in this industry. So you keep those transparent conversations about your commission with your client, because that's the only person that matters, aside from discussing your splits and everything else with your broker. Center your conversation where it matters, cover your risk, and please get a buyer's rep agreement at the front of your conversations.
100% agree. And then I think there's taking a step forward of what happens after that, right? We have to be able to effectively communicate what your value is. And you have to be able to demonstrate what your value is, right? For the last several years, it hasn't been life or death if the client knows more than you, right? You still can provide value, you can still provide services. Moving forward, you better know more than the client if you're going to be able to deliver real value, right? Consumers, and we're all consumers, we don't mind paying for something if we're getting value. You heard that earlier. You heard that from the first speaker. And that's been demonstrated. Right? Lots of examples of that. But you will not pay for something that you don't think is valuable or that you could have done yourself or you could have found out yourself. So that means we all have to become really knowledgeable at a whole nother level and also be able to communicate that value and that knowledge effectively.
I'm hearing some resonating education importance coming out here. Kind of to Romeo and Chris, with that value conversation, what do you think agents are struggling with the most in having that conversation? What are you kind of hearing is the most common setback or something that's holding them back from feeling good about that?
Well, you have to remember, you're being hired for a purpose, right? And as Chris said, I mean, you better be more educated than your client because you're relying on you for advice, for guidance, for knowledge, whether it be about the market, the area, whatever it might be. So I think, agents sometimes struggle with the fact that, you watch these shows, on TV and they go and they show 3 homes, right? And it's like, it makes it seem so easy. And obviously, every deal is unique and you have to be able to handle the objections, handle all the curveballs because, typically no 2 deals are alike. And, when you have money, people, and emotion, I mean, it makes for a very volatile situation sometimes. And as you know, sometimes you are the counselor, the punching bag, the good guy, the bad guy, everything. So know and have confidence in your knowledge and your processes and let that be the guiding light.
Yeah, I would add that also, I think the biggest place of struggle and the biggest challenge is just being comfortable having what in most industries is a normal conversation. In our industry becomes very awkward. It becomes very awkward because we either don't have the confidence or we don't understand what our value is or why someone would pay for that. I see agents do this all day long with prospecting calls, with lead follow-up, it's the same dynamic that happens where the ones that are really good, have the confidence, have the knowledge, have the expertise, and communicate it. And they don't get weird or funny or awkward about having certain conversations. I deal with and have dealt with a lot of attorneys, a lot of professionals, and they have no problem saying, hey, okay, here's what's going to happen next. This is what our fee structure is. This is how we get paid. This is what's going to cost you. You can expect to spend this. It's not a weird or awkward conversation. We have to be able to have that conversation in a way where it's not weird and awkward for us.
I'll tell you, not any one of the attorneys working on our team had a hard time telling me what their billable hour was or sending me an engagement letter. The same is true for y'all. And you make it look really easy, what you do, and it's really not easy. And I think that for a long time, it was like, if I make this a smooth transaction and nobody notices all the bumps along the way, I earn my keep. That was my value. You've done yourself a disservice in that. You did not tell that client all the bumps along the way that you solved for them. And there's a way to articulate that back to them that is not like, I'm Mary Poppins and pulled these things out of my bag, we got a deal done. You worked really hard to get it done. That's a professional service and expertise that you have that you need to articulate really clearly when it happens so that your client knows that value intimately along the way.
Emily, I'm going to ask you one more question that I kind of know the answer to, but I want everybody else to know. There have been other markets and other MLSs that have, pushed, have seen the future a little bit and have made changes to try to be more considerate and friendly to kind of what they see coming with some of this stuff. Have they experienced much change?
I think in some ways they have, and in some ways they haven't. Anytime we move even a nibble of cheese,
True.
It's hard because your workflows are hard, because your work is hard. You're in your car, you're transient, you've got a million fires to put out in a day. Like, I'm keenly aware that when we move a button, it's disruptive, and that's hard on you. And then we have to balance that with and we're trying to move you forward to new tech or new roles or new opportunities. So just know first that we know that. But yeah, I think those markets have been fine. I think they're successful, they are thriving, just as we are when we changed the conditions of our commission requirement rule last fall to allow for $0 as an offer of commission. To my knowledge, you guys are fine, and the market is still working, and things are happening just as they should be. I think some of what happens is we anticipate the change as being so painful because it has been in the past. And one of the things that I talk with my team about a lot when we go to implement a new rule or a new technology on the go forward is we got to get better at accepting this is just the course of business now. When your iPhone updates, it can be challenging, but we all make our way through it, and we still really love our iPhone, and we love the iOS operating system. The same is true for MLS.
Great
change.
analogy. Anybody else have any final notes for us or any thoughts?
I will say, if you Google, there's an NAR article that came out in, I think, October of last year, and it's 179 things that your realtor will do for you. And it's a PDF that you can download. And it talks about the listing process and all the research. If you look at that, not that you're going to go and name all 179 to your prospective clients, but it makes it top of mind. So when you are having those conversations with your clients, it's part of the value and the service that you're providing.
Yeah, I'll just add that no one has a good excuse for not being ready, prepared for any and all changes, right? We know what the possibility of changes are, and you have ample time to start preparing and start doing the things that some of the things you've heard up here that Emily said with agreements, rep agreements, and everything else to be able to be ready for whatever changes get mandated or put upon you. You then can be at the one that's affecting those changes instead of being at the effect of those changes.
Did y'all learn something? Okay. Well, thank you, panel. I appreciate it. Oh.